Child custody is almost always determined by agreement of some sort. A lot of times, though, you have to go to court, and the judge decides that. And if you do have to go to court, then the legal standard in the state of Texas is the best interest of the child. And so, what is the best interest of the child? It's very, very subjective. But there is a list from a case called Holly v. Adams with some exclusive factors, such as who the parent is that are taking care of the child, who provides the necessities for the child, the plans that the parent has for the child, the educational expectations and participation. There's a variety of different things, and it's a non-exclusive list in that particular case. So it kind of is like whatever you think can convince the judge that what your vision of what the case is what the situation should be. A lot of times the parents' work schedules are going to come into play. A lot of times, one of the ways that you prove it is you have to know your kids' teachers' names, their coaches' names, their private instructors' names if they're taking lessons on something, if they're in gymnastics or football or swimming or band. Know who their teachers are, know who their doctors are, have gone to the doctor appointments with them, who takes them back and forth to their activities, who cooks breakfast, who cooks lunch, who cooks dinner, who does the cleaning at the house, who does their laundry, who helps them with homework. These are the type of things that you have to show that you're involved in. Basically, who's involved, what are your parenting skills, what are your plans for the child, and you have to also, one of the ways that judges really fetch that out is they say, well, if I don't give you what you want, then what are you going to do? If I do give you what you want, then what are you going to do? And if you don't have an answer for both of those, that if you haven't even considered the fact that the judge might not rule in your favor and you don't have a good answer for that, then that judge knows you haven't really thought that much about it. If you don't have a good answer for that, that's a real big indicator to the judge. So you're not necessarily going to know what the things are that the judge is actually looking for. What a lot of people think that a judge is looking for is not actually what the judge is looking for. So you really need to have a good, competent attorney that will advise you, talk you through that, prepare you to testify, and that will ask you the right questions and bring that information out so that if you do have to go to court, then that will help you get the custody arrangement that you want, whether that is something that's the Texas Standard Possession Order, which is the first, third, and fifth weekend with alternating holidays and 30 days during the summer, Thursday nights overnight. And one of the issues is like, well, do you pick up from school on Thursday or and then return to school on Friday, or do you have from 6 p.m. to 8 p.m. on Thursday, and things like that? Or do you do a week on, week off, 50-50 with exchanges on Sunday, or maybe you do exchanges on Friday? What's the difference between a Friday exchange and a Sunday exchange? Because there's a big one. And then, do you do a 1 day with you, 1 day with them, or 2 days with you, 2 days with them, and call it 2-2-3, which is 2 days with you, 2 days with them, and then alternate the weekends, which is Friday, Saturday, Sunday. What custody arrangement do you do? Well, the vast, vast majority of those are done by negotiated agreement. And what you really need is an attorney that's going to look at what your particular situation is and give you recommendations about things that will work really well in actuality, but not just the things that you think or that sound like it would work, but actually don't. An experienced attorney is going to know that. So if you'd like to get an experienced attorney, go to softdivorce.com. We'd be happy to help you. In Texas, the thing that affects the payment of child support the most is the amount of income that the paying parent makes. In Texas, it's usually based on a percentage straight off of a chart. So for one child, it's 20% of what's called net available resources. Net available resources is roughly your take-home pay. So they take out taxes and insurance and things that you pay. There's a complicated formula for it. And then they get to what your net income is. And then your child support is based on that. So one child is 20%, 2 children is 25%, 3 children is 30%, 4 children is 35%, etc. The maximum they can take is 50% of what your take-home pay is for that. That tends to be the primary focus. In Texas, the receiving parent's income is not necessarily taken into consideration. However, all child custody agreements can be negotiated. And a lot of times, if we're doing what's called a pure 50-50, we will look at what both parents are making. And if they're making about the same amount of money and they both have about the same amount of time, then a lot of times we'll say no child support. You just pay for the child when you have the child. Sometimes we have it to where they both pay a certain percentage of extracurriculars that are agreed to by the parents. So as those costs come in, they'll just pay those instead of paying child support. If we come to an agreement, basically anything under the sun can affect that. And whatever good reasons that you've got, we can negotiate those. And as long as we can come to an agreement, then that's what the child support will be. But if there's no agreement, then you get what the judge decides, and the judge typically looks at a formula. The maximum also cuts off at $9,200 worth of net available resources per month. So if you have one child, it would be 20% of $9,200, which is $1,810, I think, off the top of my head. So that's the way that it's determined. Custody arrangements can be modified by agreement of the parties, and you don't even need to necessarily change your order. But sometimes if you come to an agreement without changing your order, it can create a problem for you later, especially if you informally agree that, well, we're going to switch this around and you don't have to pay child support. Well, in Texas, the Attorney General is tracking that child support, and if it's ordered, it's ordered. So if they tell you, don't worry about it, you don't have to pay child support, and you go 3 years without paying that child support, and let's say it was supposed to be $2,000 a month, well, Attorney General is going to track 3 years worth of $2,000 a month. They're going to think that that is, let's see, 2, 12, 24. They're going to think that you're $60,000, $72,000 in arrears. And then all of a sudden you've come to that agreement, and then they change their mind and decide, no, we're not going to do that. Pay me my $72,000. They can go to the Attorney General. The Attorney General will enforce that, and they will put you in jail if you don't pay the $72,000. So you have to get something in writing, and preferably a court order changed if you're going to agree to no child support as a modification of a previous child support order. Otherwise, most things you can agree on. All child custody agreements in the state of Texas begin, it's 3 sections. Section A is the definition of the word school and child. Section B is the parents will have possession and custody of the children at all times mutually agreed to in advance by the parties. Meaning you can do anything that you want to and agree to it informally between the two of you. And then Section C is, in absence of a mutual agreement, then the rest. And that's like 30 pages is Section C. If you can't agree, they list out everything: holidays, summertime, school time, every day of the week, time, location, Mother's Day, Father's Day, all that. But you can agree on whatever it is. Then if you can't agree, though, and you have to have it modified, you have to file what's called a suit affecting parent-child relationship. SAPCR, SAPSR is the acronym. So in your child custody suit, SAPSR, then you have to go in and you have to prove and show the best interest of the child. You also have to show what's called a material and substantial change of circumstances. So you have to show that there's something material and substantial that couldn't have been predicted at the time of your last order, but that's been an actual change that then is enough to justify, in the best interest of the child, after you overcome that first hurdle, that it's in the best interest of the child that the judge makes a change that the other side doesn't agree to. But if you come to an agreement, you can do any of that. But any of these circumstances, you should definitely talk to a lawyer about it, because you're not going to know which ones really need to be changed in the order or which ones don't need an order. Just make sure you get an email or some kind of proof that you actually did an agreement about that. You're not necessarily going to know, so definitely talk to a lawyer about that. But that's how it's done. Parental relocation is one of the most difficult and expensive and problematic things that we will fight over in court, because somebody wants to leave the jurisdiction and the other one doesn't. One person has a great job, and then the other person got a great job offer, or the other person needs to be closer to family for whatever reason. So you've got to go in and convince a judge that the fact that you need to do this relocation is material and substantial. And then after you overcome that and prove that it's substantial, then you've got to convince the judge that it's in the best interest of the child. And moving, every 5 minutes farther apart that you live is a 10-minute bigger problem, because you got to go 5 minutes there and 5 minutes back. Mom, Dad, I forgot my science fair project. I forgot my book. If I don't have my homework, I'm going to fail. And now I'm not going to get my scholarship. I'm sorry. You should have remembered it. because it's 3 hours back. We can't go get it. It's just not happening. So you're going to have to fail. So now your kid doesn't go to Harvard anymore, or you got to go back 3 hours or something. Like it just becomes very difficult logistically. And every 5 minutes farther apart that you move is 5 more minutes, 10 more minutes in the car for the kids. I usually recommend that, you don't want to walk out your front door and see their front door. But the street behind that, probably not too close, especially if neither one of you are like stalkers or obsessive about the other. Because if the kid's on foot, can go, oh, I forgot something at mom's house, I'll be right back. And they run, and 5 minutes later, they're back with the thing that they need. Great. That's what you want. If you're across the country, it makes it very difficult. One of the parents is only going to get seen like maybe 1 week in a month if they're going to take that flight. And then at the age of the kids, if they're younger kids, they have to have somebody accompany them. So now you have to fly an adult both ways and back and forth. And who pays for the flights? Who picks them up? It's a lot more expensive. Does the new job make enough to justify that expense? And if you're the one moving, then you're probably going to be the one stuck with those expenses. But then on the other hand is like, what if the reason is, well, they don't do anything. They never even exercise their custody, but they're making me stay here just because they like to punish me, but they never see the kids. And it's true. Is the judge going to let you move? Yeah, maybe. These are some of the biggest and most important fights. And when you're in court, I will tell you this. You have to have an answer because the judge may ask you themselves. In court, the attorneys can ask questions, but in family court, the judge can ask you questions, and they often do, almost always. And the judge is probably going to ask you, if I don't let you move, then what? If you don't have a really good answer for that shows you care and you've thought that through, the judge is not going to let you move because it shows that you're only selfish. You only care about yourself. You're not really thinking about the kids. So you really have to make sure that you put the kids first, and having both parents in a geographic restriction is important. If the other parent still lives in that geographic restriction, you're going to be required. And actually, take that back. You're not required, but the child is. And you can't take the child and move out of that geographic restriction. One of the biggest things that we fight over, if you have that problem, you definitely need the best lawyer that you can afford. If you want to get through a child custody case in the healthiest way possible, go to healthydivorce.com, and we're here to help you.